that are allotted for oral argument. With that, counsel for the petitioner, you may proceed.
Thank you.
Good morning. Before you start, just to let you know, either we have barriers here, plexiglass barriers, so we removed our masks to be able to ask questions of counsel. While you're arguing before the court, you certainly can either leave your mask on or remove it during that time, whichever you prefer.
Thank you. My name is Ken Tawney, and I am counsel for the petitioner, Ascent Resources. And I would like to reserve 5 minutes for rebuttal.
Okay. Just ask if you watch your time and make sure that you reserve that time as you speak. Okay.
Thank you. Well, we're here today on a novel issue where two judges in the same judicial circuit reached opposite conclusions on almost identical facts. The question is whether there is an implied right to pool an oil and gas lease that is silent on the subject of pooling when it is necessary to combine enough acreage to create a drilling unit large enough to use horizontal drilling techniques to develop shale formations. One judge in one case said, yes, there is. The judge in this case said, no. It's important to note that the facts are undisputed. There's an oil and gas lease on a 94-acre tract of land in Tyler County that gives Ascent 100% of the mineral rights necessary to develop the oil and gas. The lease is silent regarding pooling. It neither permits it nor prohibits it. It is necessary to pool enough acreage to form a drilling unit large enough to use modern technology to drill long horizontal wells. And pooling is little more than combining enough tracts together to form a drilling unit large enough to accommodate a horizontal well. So if you had 400-acre tracts of land and you wanted to drill a well, you need enough acreage to drill a long horizontal well. So you would simply combine those so that you could drill your well across those 4 tracts. Then production from that well is allocated to each of those leases. So if there are 100-acre leases, it's a 400-acre tract. You drill and produce 400 MCF. Each of those tracts gets 100 MCF and are paid royalty on that basis. That's all pooling is. The respondents are the oil and gas owners. They are not surface owners, and there's no surface operating rights involved in this case. They are the successors to the original lessors. Now, Ascent filed a declaratory judgment action to ascertain whether it had an implied right to pool the lease with other tracts to develop the Marcellus Shale. The respondents answered and denied that we did. Ascent then filed a motion for summary judgment, and it was supported by 2 affidavits. One said that pooling is necessary to develop shale formations using modern horizontal drilling techniques. This 94-acre lease in and of itself was not of sufficient size to permit drilling a horizontal well. The second affidavit set forth the customary terms and conditions of pooling. The circuit court denied the motion for summary judgment, which effectively denies Ascent the right to develop the oil and gas in the shale. And there were several erroneous rulings in that order. First, the Henderson affidavit said that modern technology must be used to horizontally drill long distances to develop the shale formations. Respondents' tract is too small alone to drill, and pooling is necessary to develop the Marcellus Shale. There was no conflicting evidence. The facts were, in fact, accepted by respondents. They said defendants do not dispute facts. The circuit court nonetheless determined as a factual matter that there was no evidence that assent could not develop the minerals absent pooling. That was reversible error for the circuit court to ignore the uncontroverted and admitted evidence. It was incumbent on respondents to present evidence if the facts were disputed. The next error was that the court said that silence is not an ambiguity. He ruled that the lease was unambiguous because there was no express provision permitting pooling, and the parties had operated without incident for 39 years without the need for clarification. The circuit court failed to recognize that the purpose of a declaratory judgment action is to declare the parties' rights, the future operating rights, so that they can go in and spend huge sums of money to drill horizontal wells, knowing that they are within their rights to do so. They cannot afford the risk that a $10 million investment in a well is going to be taken away from them in a trespass action, or an injunction action is going to be stopping them from drilling.
Counsel, if I could ask just, and I know that you're arguing that the only way to economically drill for this gas is through horizontal drilling. And that is although it's been done for some years, it's fairly new technology that maybe wasn't envisioned when these agreements were written. But would it be, when you say that the only way to do it is to do it that way, would you be able to, short of having a term implied by this contract, go to those individual lessors and get an agreement to be able to pull these without having it applied from this agreement?
Maybe or maybe not, Your Honor, and that's part of the problem, because any one of a number of lessors could refuse to sign a pooling amendment. And that's one of the huge problems that we have to face up to. And all we're doing here is enforcing the contract as written and interpreting the ambiguity in that lease as to whether or not you can use modern technology to drill horizontal wells. So,
Counsel, aren't you asking us to do what the legislature has been unable to do in the last couple of sessions?
no, Your Honor, and that's one of the common misconceptions. This is not a forced pooling case. This is simply a contractual interpretation case. And it's something that this court has been doing since at least 1902.
But you're asking us to imply, 5 new paragraphs of obligations into this 1980s contract, and that would, in effect, if we imply that, result in forced pooling.
Well, Your Honor, I disagree. What it's going to allow is the development of the oil and gas estate that is consonant with the terms and conditions of the lease. That was the overall bundle of rights that was granted in the lease. And, I'll jump ahead to the implied covenants cases, and this court in Buffalo Mining v. Martin adopted a two-pronged test to determine whether there should be an implied right to do something. And if you look at every one of the implied covenants or implied rights case, the lease or the deed or the contract at issue was silent on some point. And the court said, is this reasonably necessary to accomplish the purposes of the contract? And the second prong, can it be done without any undue burden on the lessor? And The uncontroverted facts here say that yes, it is reasonably necessary in order to exercise the rights under the oil and gas lease to develop the oil and gas in the shale formations. Was there any evidence of burden on the respondents? No, there was no evidence. All that they argued without evidence was that they were going to be unable to get more money that they were not contractually entitled to for a pooling amendment. And
Counsel, you mentioned, obviously, the facts suggest that the 94-acre lease is insufficient to support the drilling of a horizontal well. What does the facts show in terms of how much additional land is necessary and what rights are being impacted if this court would find that there is an implied right for forced pooling?
well, first of all, the producer would have to have 100% of the rights in all of the tracts that would be involved in forming the drilling unit. So again, there's no forced pooling involved. And the size of the unit is going to be a function of how long the well is. I mean, the facts in the Henderson affidavit was that at that time that you were probably going to have to drill a well about 5,000 feet in length. And it's common to be drilling wells up to 10,000 feet in horizontal length, so almost 2 miles, and some are even longer. So it's a function of what's the drainage area going to be in that unit, usually about 500 feet on either side of the well, and then you just calculate the acreage. So if this tract is right in the middle of that, or near the beginning of a proposed unit, it could result in them not being able to form the unit, and not only is the producer prevented from exercising his right to develop the oil and gas, but all of those subsequent landowners are also going to be prevented from benefiting from royalties from a successful well.
Counsel, just when you talk about implying the right, and my concern is this, and I'd like your response, is if you imply the right to pool, and you say that the silence in the agreement, would be interpreted one way or the other, either the right to or it's prohibited by this, the silence. But if you take your approach and say that if it's silent, then there's the implied right to pool, aren't you going to then have to imply a number of other provisions? For example, some of these leases, and not necessarily this one, but as you start looking at individual leases and how they're written, some are held by the production on that piece of property. So are we going to then imply as well that even though you didn't drill a well on this piece of property, that by horizontally drilling underneath it, that qualifies for production under that? And there are a number of different provisions that I think you would have to imply in these agreements if you imply that right to pool is there. And also you would have to imply what the person is entitled to under royalties, even if there are specific royalties in those agreements. So I guess where does that end in terms of if you imply that there is the right to pool, how many other things do you have to imply basically in that agreement for that to move forward?
Well, Your Honor, first of all, the royalties would be paid on the basis of the production allocated to that tract, based on the acreage in the unit. And in the Stern v. Columbia Gas case, the federal court had no difficulty in saying that is the way to allocate the production. You do it on the basis of acreage. In that case, the court said there was an express right to pool, but that lease did not have any of the terms and conditions governing pooling set forth in it. So the court said that's fine, you don't It's standard in West Virginia that the lessor gets its allocated share of production, and the royalties under the lease are paid. Now, I'm not sure that there's anything else that needs to be implied. I mean, yes, well, any tract in that unit is going to be held by production. Now, I've never thought about that precise question of whether it would need to be implied or not, but certainly it would be held by the drilling.
What if it's held by the terms of the lease by the drilling of a well on that property? Would this be considered drilling a well, even though it's not a surface well?
Oh, yes. I mean, any
But
tract.
isn't that implying that?
In any
It's not
tract.
really the terms, it would be implied by that, right?
Yes, any tract that is included in that drilling unit. And, got to remember that they had to go to Office of Oil and Gas and get a permit in which they show here's the units that we're proposing, here's the size, here's all the lessors that are included in it. And of course, they design those wells so that they can maximize the production. So yes, any tract that is included in that unit is going to be held by production, but it's defined, and it's common to record that unit declaration in the county clerk's office so that everybody has notice of exactly what size the unit is and what tracts are included in it. And in fact, that was one of the terms and conditions of pooling that we presented to the court below, and the defendant or the respondents did not question that. It's undisputed evidence in this case.
If you had 5 tracts that you were trying to pool and each of them had different royalty provisions, how are you going to decide what royalty applies?
Well, again, if you go back to the 400-acre tracts in a 400-acre unit, each one of those 100-acre tracts gets 25% of the production because they have 25% of the acreage in that unit. So,
But someone then is probably going to get, again, an implied percentage that if their agreement says one thing and you're now pooling it with others, aren't you somewhat undermining those terms that are already in that agreement? If you say you're going to get this percentage of whatever the royalty is?
well, I mean, let's say that one lease had a different royalty provision than another. I mean, is that the
Yes.
question?
Yeah.
Well, you apply the terms of that lease to the allocated production. So I take the 25% of production that I got. This lease provides for a 1/8 or 12.5% royalty, and I apply that 25%, and I get 1/8 of that 25% of the production as my royalty. So you're not monkeying with the royalty provisions at all.
Yet you're assuming that each one of those 100-acre tracts is going to provide the same amount of production. And that or that may or may not be a reasonable assumption. One acreage could have more gas than the other, but you're assuming that every 100-acre tract is going to produce exactly the same amount of gas as every other 100-acre tract. And that is an assumption that you are making, or you're wanting us to make and say, regardless of what the actual production would be from a particular 100-acre tract, you're assuming that everything around it is going to produce the same thing, right?
That is correct. We're making an allocation based solely on acreage. Now, I think it's a valid assumption because, again, you have to take your well-designed plan to the Office of Oil and Gas, and if they believe that you've designed your well wrong, they're probably not going to give you a permit. I mean, we didn't get into that, obviously, but to answer your question, they're going to look at the horizontal length, they're going to look at how the well is fractured, and they're going to determine what gas is being produced from the well in that unit. So I think it is a very reasonable assumption, and certainly the way that the state has been operating now since 2008 when horizontal drilling was first introduced. That's the way it's done.
How do you, again, this court spoke in the last year or two about obviously the change in the technology, going from vertical to this court authorizing horizontal drilling, hydraulic fracking. But how do you equate the, quote, efficiency argument as you're making here to make horizontal drilling financially viable? You need to be able to access these additional tracks. How do you equate efficiency to technology change that this court has at least embraced?
Oh, yeah. I mean, in the Andrews versus Santero case, the court, clearly held that silence in those deeds was an ambiguity, and that
for a change in technological. But
yes,
get me beyond the change in technology. You're now making the argument of efficiency, that we ought to embrace the same approach of change in techniques and technology, but also change in the efficiency, the financial viability of the technique to make this production warranted.
well, to encourage the development of the resource, it has to be economic. People are not going to go out and drill uneconomic wells. So, drilling the old traditional vertical well into the 94-acre tract is not going to produce enough gas to make it economical to drill that well. So obviously that is going to be the driver for any development of the Marcellus Shale or the Utica Shale in this state. So the only way to do it is through efficiency, and the only way to gain that efficiency is to put together enough acreage to make it economic to drill a long horizontal well that will cost a minimum of $7.5 million and another $2.5 million to do the pad, construct the pad. So you're talking about a significant investment, and nobody's going to go out and drill wells that they don't think is economic. So the result of not having an implied covenant to pool means that the tracks will be not be drilled. And that's a practical consequence of it.
It seems to me you're asking this court to embrace an approach that says just that in practice the producer would look simply to get enough of a footprint to be able to drill, and then through these court decisions based on economics and efficiencies, the sky's the limit, because once you get down and start drilling horizontally, there's no limitation on where that length stops if we adopt your approach and say there's an implied right to be able to pool.
Well, Your Honor, I hate to get into all of the possibilities that might come back to this court at some future time. I mean, it's just like Williams and Myers said. The law of implied covenants developed because of the unforeseen and unforeseeable changes that are going to occur in the industry, whether it be legal or political or technical. And that's why the law of implied covenants steps in to address those changing situations as we go through time. And that's why the court developed the two-pronged test in Buffalo Mining, was to look at each issue and decide based on its own merits. So I hate to speculate, about what other situation might be presented to the court. But in this case, we have the uncontroverted evidence that pooling is necessary to develop it, that you can't develop this 194-acre tract without it, and there is no burden to the respondents. And, if you apply the uncontroverted facts to that test that was adopted in 1980, that's the result, that's the logical conclusion, that you do have the implied right to pool. And you have to think of it this way. There is already in the law an implied covenant to develop. The court, most recently in the St. Luke's Methodist Church case, said, producer, you have an implied obligation to go out and do what is necessary to develop this tract of land. And if you don't, you can face lease termination.
Counsel, I want to cut you off, but the time's pretty much expired. I know we asked you a lot of questions, but if you want to have any time at all to rebut,
okay,
conclude your argument.
Thank you.
You want to grab your microphone? That's okay. May it please the court, my name is Jeremy Cooper, and I represent the respondents Donald Huffman and Triple L Land and Mineral LLC. There are kind of two different branches to this appeal and the issues that are that the court needs to examine. There's the micro issue of the specific facts and circumstances of this lease in this particular parcel of land in Tyler County, and there's the broader issue about the implied right to pool and unitize that the petitioner is asking this court to recognize. So I'm going to start on the micro level and then go to the macro level. I believe that Judge Kramer was correct in denying the motion for summary judgment and denying the declaratory judgment in favor of the petitioners because the declaratory judgment action was deficient in the first place. There was not an explicit pleading even of an ambiguous lease, which is required under Cotiga development for a court to construe a contract. It was not even explicitly pled, and it certainly wasn't proven. The fact that the lease doesn't say anything about pooling and unitization is not enough on its face to determine that it's an ambiguous lease. The right to pool and unitize, the right to use the subsurface strata to move other gas from other parcels, the right to commingle the production from one estate to and pay out other parcels with gas produced from an estate. Those are all contractual rights, property rights that can be transacted or not. And in this case, the pooling rights were not transacted in the lease. That doesn't make it ambiguous. Pooling was something that was recognized in West Virginia law at least as far back as 1974. This lease took place in 1980, and it simply did not transact the right to pool. That doesn't make it ambiguous, and the entire argument about silence equating to ambiguity isn't something that was raised below. So just as a basic pleading matter, the declaratory judgment request, I think, fails, and I think the judge was correct in denying relief on that basis. But even if we just assume, for the sake of argument, that it was an ambiguous lease, then what the court needs to do at that point is look at the circumstances of the contract and determine what the intent of the parties was. And there's nothing in that contract, nothing in the record that suggests that it was the intent of the parties to pool. Of course, the most salient issue is the fact that there was no pooling provision in there. It was not transacted. It wasn't decided to sell that right and to pay for that right. But beyond that, the lease repeatedly uses the language drilled on the premises. It contemplates the drilling of wells on the premises. It contemplates that the original lessor would assist with determining where the drills would be sunk on the premises. It clearly did not contemplate that this 94-acre unit would be combined with a number of other units, and the rights under those would be commingled and paid out pro rata, or however else it winds up being paid out under the various different leases that would exist in that unit. There's nothing to suggest that that was the intention of the parties, that that was even contemplated by the parties. And certainly this court has held that oil and gas leases should be construed against the lessee, against the party that produced the or drafted the instrument in the first place. And I think there's a presumption in those cases that would suggest that the oil and gas company and not the individual landowner is likely to have been the sophisticated party in producing those. So just on the question about whether there was any ambiguity whatsoever, or if it was ambiguous, what the intentions of the parties are, just in terms of this particular parcel, there's nothing that would justify the circuit court granting relief to the petitioner. The other factual premise underlying the request for declaratory judgment is the idea that the minerals in the lease cannot be produced in the absence of pooling and unitization. And that's simply, it's almost a paradox. It cannot possibly be true. The lease specifically states that it will remain in force for a term of 10 years from the date of signing and as long thereafter as oil and gas or either of them is produced from the said lands by the lessee. It's been 40 years since that lease was signed. In the original complaint, the petitioner stated that the subject lease is valid and subsisting oil and gas lease in full force and effect by virtue of an existing well or wells in operation of the premise for production of oil and gas. So they even admit in their pleadings that the parcel is being used to produce oil and gas. It is not necessary to use pooling and unitization to produce oil and gas, full stop. And what the petitioner is doing is conflating the ability to produce from certain deep strata with the ability to produce under the lease at all. But the circuit court was correct in determining that there's no evidence that the leasehold wasn't producing oil and gas. Just on the face of the pleadings and just using basic logic and looking at a 30 years after the primary term of the lease, we still have an active lease. There's no way that this couldn't be producing. If it's not producing, then there's no lease in the first place, and that in itself is a reason to deny relief because the lessee would have no rights under the lease.
Okay, Counsel, let me ask you on that point. So is there a well currently on this lease? Is there a well?
Well, Your Honor, according to footnote 21 of the reply brief, the outside the record theory is that there is some type of flooding practice being used to force minerals out of a formation, but that there's not an actual oil and gas well located, specifically drilled on the parcel. That's what is represented by the petitioner.
So I guess I should ask, is there a vertical well?
I don't believe there are any vertical wells on the lease. Notwithstanding what was pled in the complaint, I don't believe that there's actually any oil and gas well located on the 94 acres.
So is it your client's position that this lease is still valid or is not valid, that it's expired from lack of production?
Well, Your Honor, I know in the complaint and the answers, the defendants both originally denied that the subject lease was valid and subsisting. So to that extent, it appeared that they denied that that was the case, although that was not discussed at any length in any of the motion hearings or responses or anything of that nature. So, to the extent that they pled that in the answers, then I can say it's their position that it's not a valid lease. However, that doesn't appear to be the basis upon which the circuit court ruled. The circuit court apparently ruled that it must still be producing because it has been, the lease has been in effect unabated for all these years. So I think, you either have a producing well or an invalid lease. Those are the two options. You can't have a lease that's valid 40 years into this process if it hasn't been producing in the interim.
So if there is a producing well, though, and I don't mean to belabor this, but then it is basically being done horizontally, right?
I don't know enough to answer that question one way or another. I don't know. Again, that wasn't in the record. It was contained in the footnote, and perhaps the petitioner can comment as to that. My understanding is that there's not actually a well bored on that land. So whether it's horizontal or whether it's just on some adjacent parcel, and I don't know exactly how it works. I could only speculate.
Let me ask you this. If you have a situation where we have here, and you've heard the petitioner's argument that the only way to efficiently or economically produce is with a horizontal well. And if that's the case, and you have this lease that goes back to 1980, then there are two things that could happen. One being that he reaches an agreement with your client to allow it to be done that horizontally. Or if your client just says, no, I don't want to allow this to happen, then he can't produce, right? So does that make his lease worthless if your client just said, I don't wish to agree to this?
Well, it wouldn't make the lease worthless because apparently there is still some production being generated by it, but I understand the question. I don't think that the prospect of a property owner declining to transact additional property rights is a reason to override those property rights altogether. I don't contemplate that that's what's happening here, and certainly in the case before Judge Hummel, in which Judge Hummel ruled that there was an implied right. In fact, the petitioner paid an undisclosed sum of money in order to get the consent to enter that. So it's certainly within the realm of contemplation that there could be cash settlement in order to get these rights that were not previously transacted. If the respondents chose not to transact and to prevent it, then I suppose that is the nature of property rights, that one who has a right can choose not to transact in it. I understand there are policy considerations there, but I think that is how our system of property works. You don't have to sell unless you were forced to by eminent domain, some other phenomenon like that. So if a person chose the stone wall, then I believe that's their protected right. They don't have to transact if they don't want to.
Justice Hutchison asked a question to petitioner about is this more appropriately left to the legislature, and my sense is the petitioner said that what we're discussing here is different than the legislation that had been worked on downstairs. Do you share that same view that this is separate and distinct from the public policy debate in the legislature about pooling, or do you see this really is an issue in this particular case that should be left up to the legislature?
Your Honor, I agree with the petitioner to the extent that what was being discussed in the legislature in 2016 was not the same issue as what we're looking at right now. It had to do with forced pooling of non-leased rights, but I do believe it's of a similar kind and should be is something that is within the realm of what the legislature should consider. If the legislature wants to pass a law that dictates that the leases are to be construed in this manner, if that can survive constitutional challenge as a property taking, then that would be one way that this conundrum could be solved, I suppose, for the industry. But yeah, I believe that is something that's within the realm of what should be considered by the legislature, as opposed to by this court in the context of a property dispute over a mere 94 acres.
And let me clarify something. Did the court rule that the lease was valid because it had been effectively been left in place for 40 years and that, so that there obviously must have been some production, so he concluded that lease is valid? Is that what the court did in this case?
So the court said that there was no evidence presented that the lease was not producing, I believe is how the judge worded it.
A negative inference, you know. Nobody told me that it wasn't producing, therefore I must conclude that it is producing.
Right. I mean, I think the judge is entitled to look at the pleadings in a summary judgment case and can determine from the pleadings that it must have been producing based on the fact that we're, you know, in year 40 or at that point, year 36 of the lease.
Okay.
But yes, that's how the judge phrased
Has
it.
your client ever paid any production royalties on this?
I don't believe my clients have owned the land for very long. I do not, frankly, know if they have or not, Your Honor.
Just one last question. If you've heard the petitioner talk about the fact that you can't, when you have older leases like this, which this is not relatively newer compared to some of the others that this question has been raised on, if you don't have an implied covenant to be able to produce horizontally and to pool in order to do that, where do you see that line being of, as technology progresses and different procedures are either physically viable or economically viable, where do you see that line of when there should be an implied right to do that because that was what was envisioned by the parties to produce?
Your Honor, I think that if you have particular lease terms that, or circumstances surrounding a lease that suggest that the intentions of the party were to do so, then a court should so find. Like in the case before the Northern District, Stern versus Columbia Gas, they looked at the lease and they found that it used language conjointly to describe the production with that tract and other tracts. That language is, of course, absent in this lease. So you can look, in certain circumstances, I think the facts will support the premise that there is a right to produce, but I don't believe that it's something that should be adopted as an implied right. That would go against, you know, the century worth of implied rights and duties law that this court has handed down, all of which, at least all of which that have been quoted by the petitioner in their brief, were served to protect the interest of the mineral estate owner, either from the lessee on the one hand or the surface owner on the other hand. You know, essentially what the petitioner is asking for is a transfer of property rights without compensation and potentially on a large scale. I don't know how many leases of this nature exist or exist in places where this type of production is contemplated, but what will happen is that rights that were reserved, if they were indeed reserved under leases, will be transferred wholesale to the lessees. And I believe that that would be an unjust outcome for the mineral estate owners of West Virginia. I would ask the court not take the petitioner's invitation to engage in that type of wholesale transfer.
What is the property right that I mean, I know that it's how you get there, but the property right that was transferred was the right to produce the gas, right?
Yes, Your Honor.
And we're talking about two different ways to produce the gas. And according to the petitioner, you need to imply in this agreement that the only way to produce it is horizontally, and therefore we don't need to drill a vertical well on each piece. We need to pull them together to do this. So what's your response to the fact that rather than you say there's an additional property right that would be transferred, what is that property right that wasn't originally transferred in the original agreement?
So I think the property right can be conceived of in a number of ways. One is the right to be the recipient of the proceeds of the gas that's produced under your own property. If you're pooled and unitized, irrespective of how much gas is actually produced from each parcel, just as Justice Hutchinson was discussing earlier, the proceeds will be parceled out amongst the various people, and that's not something that was agreed to under this contract. Also, there's the similar to the idea that was discussed in the surface rights case, Crowder, there's the use of the actual mineral state to transmit minerals for somebody else's production, which, depending on the type of severance that was done, could be implicated or not. But these are rights certainly that the petitioner doesn't believe that it has at this point because it fears the trespass actions and it fears, breach of contract actions. So I think that it's fairly straightforward that unless the court orders that it does have this implied right, then these are property interests that it doesn't currently possess. Thank you, Your
All
Honors.
right, thank you. Maybe you have a brief rebuttal.
And while you're putting your microphone cover on, I'll ask if you could comment on the discussion during respondents' argument about the validity of the lease.
Yes, Your Honor, I can. And let me say up front, it's not in the record, okay, because, we said we had a valid lease and that was not challenged. The simple fact...
And that's enough for, I'm just curious what your position was on it. You don't have to stray off the record to answer the question.
The lease is held by production because it is in a pooled unit for the Wolf Summit secondary waterflood operation. So that's the royalties that they're entitled to currently, is their share of the production in that whole unit from that waterflood operation that I think is still owned by Dominion. So there is not currently an operating well on that particular 94-acre tract, I don't think.
But for present purposes, that was just simply not an issue that came up.
It was not an issue. It was not an issue below. And the lease validity was assumed, and it is a good lease. It sort of gets back to Justice Armstead's point that, yes, the pooling of that acreage with others would hold that lease. And that's how it's being held now. So just a few points. The respondent is raising for the first time on appeal this issue that the lease should be construed against the drafter. That was not raised below, and it shouldn't be considered here. And just on the merits, it would set all of the implied rights and implied covenant cases on its head, because none of them construe the ambiguous document against one party or the other. The court simply looks to see whether the right sought is included in that overall bundle of rights that was granted. And then, if it's an implied rights case, they look at whether there was a burden to the respondents. The court would limit our right under the lease to the shallow sandstone formations. And how that interpretation could be in the public interest and why this court should adopt that is beyond me. There is no limitation of the production rights and the drilling rights to the sandstone formations, but yet the court said, well, for 39 years they've operated, and they are producing oil, so it has not been prevented. But again, what we're talking about is a declaratory judgment action to see if we have that future right to form this pool to drill the wells.
Counsel, can I ask you just one quick question, just more technical, and you may not know this, so if not, I understand, but you made the reference in your argument that this was a sort of a split of authority between Judge Hummel's opinion in the previous case, or an additional case. Do you know, and my understanding from that case before Judge Hummel, and like I said, you may not know, but is that the issue as to whether there was an implied right to pool was originally contested, and then the challenge to that was withdrawn. Is that your understanding, so that there was really not a challenge to the question as to whether there was an implied right in that case?
Your Honor, yes, I can speak to it because I was the attorney in that case that argued the motion. I did not in this case, but in Judge Hummel's case, I did. And yes, there was an agreement reached with the guardian ad litems shortly before the hearing, but we still had to go to the hearing. And trust me, Judge Hummel asked a lot of very difficult questions and put me over the ropes, and he did have opposing counsel to present their arguments in opposition to it before he entered the order and held that we did have the right. And he actually, as I recall, he said during the hearing that he had changed his mind during oral argument on that summary judgment motion. So,
but it was ultimately not contested, is that?
That's correct. Well, yeah, I mean, ultimately, they reached an agreement, and which would probably happen in most cases, rather than go to the expense of litigation and sometimes the attendant delay. They're going to try to work something out with parties.
Well, effectively, wasn't what Judge Hummel was doing in that case, reviewing it, making you go through your arguments, because he had to make a decision as to whether or not it was in the best interest of the wards to do what you all proposed. So you came to an agreement and then had to present that to him and convince him that it was in the best interest of the wards of the state, right?
Well, that's in effect, I think, what he was doing. He was making sure that it was something that
So
he thought was the right thing to do.
So his focus was a little bit different. His focus was, is the agreement in the best interest? Not did you have the right to imply?
Now, that was not the way he went about it, though. He was, why should I grant this implied right to pool? I mean, that was, he made us justify the motion for summary judgment. And so I don't think we're affecting any property rights that we don't already have. We're not asking for any property rights that we don't already have. We already have the right to do whatever is reasonably necessary to produce the oil and gas in this tract. So I think.
Do you have any response? Obviously, the respondent suggests that this 1980 lease effectively postdates the 1974 pooling ability, and therefore its silence in 1980. It could have addressed pooling, but its silence suggested it did not. Give me a framework of the pooling technique and approach and leases entered after 1974, and including language relating to pooling.
Well, I think it was the the Andrews v. Antero case that actually looked at that, and they said, well, the first answer, let me say, is that there was no evidence of what the party's intent was at the time that the lease was entered into. The record is devoid of anything that the parties did or did not think about or intend. And so again, we're simply faced with silence, and any speculation by the court or by the respondents as to what they did or did not think about is just that. It's speculation. And if they had any evidence that pooling was prohibited, they could have come forward with that evidence, but yet they submitted no evidence of the party's intent. But this court has already said that the intent of parties to an oil and gas lease is to produce the gas and pay royalties. You know, a lease yields nothing if it's not worked. A lease is for the mutual benefit of the lessor and the lessee. That is the intent of the lease. I mean, McCullough Oil, Steel Smith case, Garton, that's the Brewster case. That's what they say. We know what the intent of the parties are. And I think in Parish Fork, this court stated, and forgive me for reading, but we recognize as universal the principle of law which discourages tying up and rendering unproductive the vast fields of mineral wealth, construes every contract and lease as to both lessor and lessee so as to promote production, development, and progress, and frowns upon every attempt to evade it as being in contravention of both good morals and public policy. And those words are as true today as they were in 1902 when the court spoke. And so what the court has an opportunity to do is to promote the production, development, and progress, which is consistent with the legislative policy, and discourage tying up and rendering unproductive this vast Marcellus shale formation that we have in our state.
Counsel, I believe your time is pretty much expired.
Thank you,
I
Your
know we
Honor.
asked a lot of questions of both counsel, and we both argued this case very well. I appreciate the arguments, and with that, this case will be submitted. Thank you very much.
Thank you.
The next case for oral argument is also under Rule 20, Everett Frazier, Commissioner of the Division of Motor Vehicles versus the Office of Administrative Hearings and Clarence Sigley. Docket number 19-0362. This is an appeal from the Circuit Court of Kanawha County, West Virginia. And counsel, I would like you to know that although Justice Workman isn't here present in the courtroom today, she will be participating by viewing and listening to the webcast, so she will participate in the decision and opinion in this case. I'll remind you that you each have 20 minutes to present your oral argument. I've just been advised that counsel for Mr. Sigley, Todd Lenev, does not plan to appear for oral argument. As you know, he filed a summary response. So the respondent will have the entire 20 minutes, as will the petitioner. So with that, petitioner may proceed.
And counsel, as you prepare, just to let you know that if you may wear your mask when you're addressing the court or remove it, whichever you prefer.
I'm Elaine Storage, Assistant Attorney General, and I represent the Commissioner of the Division of Motor Vehicles. Unless this court would like me to refresh its memory about the facts of the case, I will proceed right into my argument. This is a case of procedural gamesmanship. Mr. Sigley pled guilty to DUI, and we're playing games to determine if anything other than a license revocation is possible here. For purposes of West Virginia Code Section 17C5A, subsection E, a person is convicted when the person enters a guilty plea. Mr. Sigley, his counsel, the assistant prosecuting attorney, and the magistrate of Harrison County all signed a plea agreement showing that Mr. Sigley pled guilty to first offense DUI. Once a driver pleads guilty to a DUI offense, the commissioner is mandated to revoke the driver's license. The Office of Administrative Hearings egregiously exceeded its jurisdiction by entering an order determining that the DMV did not have authority to revoke Mr. Sigley's license under 17C5A1A. As this court determined in Reed versus Thompson, the only OAH only has as much authority as the legislature gave it in statute or rule. Pursuant to the OAH's enabling statutes, the OAH has authority to hear and determine appeals or revocation orders under Chapter 17C, but there are limits on the OAH's review. Under 17C5A1A, subsection C, the sole purpose of an administrative hearing is for the driver to present evidence that he's not the person named in the guilty plea. Sole means expressly excluding any other authority to hold a hearing. There's nothing in the OAH's enabling statutes which gives it power to hear anything other than identity if the driver contests identity, and 17C 5A1A subsection C specifically limits the OAH's jurisdiction to contested issues of identity. The general rule of statutory construction requires a specific statute to be given precedence over a general statute. And the OAH would only have jurisdiction over the instant matter if Mr. Sigley had brought a claim of identity before the tribunal. He did not. To this day, he's never alleged that he's not the person who entered the guilty plea. Therefore, respondents' argument that the DMV has conflated the OAH's authority to hear an appeal with evidentiary basis on which the OAH could sustain an appeal is disingenuous. The evidentiary bases are non-existent here. When the DMV revokes upon conviction, the only evidence the OAH is permitted to take is identity, and there's no dispute to that here. Moreover, the OAH has routinely denied hearings where there's a conviction and sent the driver a notice saying that they've not raised the issue of identity and that that's the sole issue at the hearing. The OAH did acknowledge that the DMV has, and to quote the OAH, the authority to determine whether a person has been convicted of a DUI offense or has entered into deferral under 17C5-2B and to enter an order revoking the person's driving privileges for committing a DUI offense. Yet the OAH took it upon itself to interpret if the DMV's revocation upon conviction was proper. If Mr. Sigley wanted to contest the DMV's authority to issue a revocation order under 17C5A1A, then Mr. Sigley should have filed a petition for writ of prohibition in the Circuit Court of Kanawha County. He did not. He only threatened to do so. Under the contested case provisions of 29A52B, Mr. Sigley was required to raise an identity issue when he appealed the revocation upon conviction. He did not. Instead, he used what is typical DUI defense counsel boilerplate that says, I'm raising every single defense that I possibly can. But he never once said, I'm not the person named in the guilty plea.
But we're not dealing with 17C5, are we? We're dealing with 6111.22A, because that was where he made his conditional plea, right?
That's what he tried to do, Your Honor. Yes, he tried to sneak it in under 61, even though this...
He did sneak it in under 61, because, in fact, what happened was he made the agreement with the prosecutor, and of course it was before the case that said you can only use 17C in a DUI case, and effectively completed his deferral period and was, in fact, never convicted, because even though he entered a conditional plea, a plea has to be accepted before the individual is convicted, and that plea was never accepted. Is that correct?
Under the 61, that's correct, but that's not, the DMV's position is that 17C5A1A, subsection E, says that a person is convicted when the person enters a guilty plea, and the DMV
What does the statute say in terms of what you have to use to determine whether he was convicted?
Your Honor,
doesn't it say you have to look at, I can't remember the exact...
Transcript of conviction.
Say again?
The transcript of conviction?
The transcript of conviction, and there's no transcript of conviction in this case.
But that's not for the OAH to determine.
Well,
That's Mr. Sigley's fight in a writ of prohibition against the DMV. The DMV is mandated to act when a conviction is entered, when a driver pleads guilty. And according to 17C5A1AE, a person is convicted when the person enters a guilty plea. And if Mr. Sigley wanted to fight that battle, he should have filed a writ. It's not for the OAH to...
The DMV put all of its eggs in one basket because it had two opportunities. It had a C case. I hate the way they do that. It's the same number with a C and then the same number with a D. And the D case was the conviction case. And the C case was based upon the filing of the officer's
DUI information sheet.
DUI information sheet, correct. And so whenever DMV saw that, oh, we've got a conviction here, they dismissed the C case. And
Generally-
went under the D case, right?
Generally, the DMV does not do that. What occurred here was when the OAH denied him a hearing because he was convicted, and then Mr. Sigley sent an email to the OAH saying, hey, wait, why am I entitled to a hearing under C but not D then? The OAH, the DMV said, well, we'll just make it easier on the OAH, and we will rescind the C file, which is the revocation based on the DUI information sheet, and because he pled guilty, which is a conviction.
But he was not convicted. That's the key issue here. The key issue is under 611122A, which was, today would be the improper way to do it. No problem. But all this occurred before we dealt with that issue up here. So he effectively was not convicted of driving under the influence. Is that true? Under 611122?
If this court is considering 61 at that time valid, then he would not have been convicted. But that's not for the OAH to say whether the DMV did it right or not. There's no authority for the OAH to say whether the DMV got it right or not. All the OAH has authority to do at these hearings is say, if Mr. Sigley is the same Mr. Sigley who entered the guilty plea, and then it can go forward on Mr. Sigley's appeal or Mr. Sigley.
You're conflating guilty plea with conviction, and that's the problem that I'm having, because he was not convicted. He may have tentatively pled guilty, and if he didn't meet his deferral requirements, that would have been accepted, and at that point in time, he would have been convicted. But a plea and a conviction are two different things, and I think that's the problem I'm having with this case.
But 17C5A1AE defines conviction as when the person enters a guilty plea.
Well, but that's not the one we're working. That's not the statute you're operating under. So that's where I have my problem.
That's the statute that the DMV did act under for these purposes. And because the DMV revoked upon conviction under the 17C5A1 statute, all the OAH had authority to do was have a hearing for identity if the driver contested identity. There's no contested case here. And under 29A52B, he was required to contest identity in order to have an administrative hearing before the OAH. He did not do that. The DMV then filed its writ of prohibition in the Circuit Court of Kanawha County, and the Circuit Court did not consider the DMV's arguments below. It just summarily dismissed the matter, did not even have briefs, didn't even let the other side file a response. The Circuit Court summarily dismissed the matter without looking at the DMV's arguments, and we believe this is a matter of law. The OAH has limited authority to hold a hearing for the sole purpose of identity and not to interpret the DMV's actions in revoking upon conviction is a limited issue of law which we think this court must address. Thank you.
Good morning, Mr. Chief Justice, and may it please the Court. Thomas Lampman, Assistant Solicitor General on behalf of the Office of Administrative Hearings. The Office of Administrative Hearings is an independent appellate tribunal tasked by the legislature with hearing appeals from the DMV Commissioner's orders of license revocation and with making independent conclusions of law in its rulings. Interpreting statutes is an inherent and an unavoidable part of that mission. Yet the DMV's argument is premised on the idea that the office does not have the jurisdiction or the power to do that very thing, the very thing that it was created to do. These arguments are contrary to law and they are illogical. The jurisdictional challenge petitioner raises here is not based on the office's actual jurisdictional statute, the statute which contemplates none of the limits that petitioner attempts to graft upon it. Similarly, petitioner's attack on the office's powers ignores key statutory language which expressly requires hearing examiners to make conclusions of law when deciding appeals. The very premise of petitioner's arguments here, and the arguments that the petitioner made before the office in the first place, underscores why these arguments are wrong. There's ultimately no practical way for an independent appellate tribunal like the office to function if it cannot interpret the statutes that bear upon the questions that it faces. The premise of DMV's argument is that the office doesn't have the power, essentially, to disagree with the merits arguments that it makes before it. There's every reason to conclude that the office, as an independent appellate tribunal, should not be subordinate to either of the parties that appear before it. So, turning first to the jurisdictional challenges that petitioner raises. The office's jurisdictional statute, 17C 5C3, speaks in direct and unqualified language. And forgive me for reading, but the office has jurisdiction to hear and determine all appeals from decisions or orders of the Commissioner of the DMV revoking any license for violating the provisions of any licensing law contained in Chapter 17C. And that's precisely what took place here. The DMV Commissioner issued an order revoking Mr. Sigley's license pursuant to the DUI statute in Chapter 17C. Mr. Sigley took a timely appeal from that order. Petitioner is right to say that it was petitioner's fight to contest that order, and that is precisely what he did. He objected to the Commissioner's order before the office. The jurisdictional statute sets clear boundaries, and petitioner's case falls squarely within those. Petitioner's arguments go to the merits of Mr. Sigley's appeal, and that's why the Circuit Court was correct to reject them as premature. It's accurate to say that the DMV revocation statute calls for a hearing, which the OAH was prepared to have here, and provides that the sole purpose for that hearing is for the person to present evidence that he or she is not the person named in the transcript of the judgment of conviction. The statute does not speak to jurisdiction. This is not part of the office's jurisdictional statute. This speaks to the substance of a hearing that the statute acknowledges the office will have. And even if the merits of Mr. Sigley's appeal were relevant to determining the office's jurisdiction, it's not a frivolous argument that Mr. Sigley is making here. Petitioner emphasizes repeatedly the word identity, but the word identity does not appear in the statute. The statute turns on whether a conviction was entered. Subsection E, as petitioner points out, defines conviction as occurring when a plea of guilty is entered, but it's not clear that that's what was done in this case. So whatever the outcome of that question is, whether a plea was entered or not, leads to the unavoidable conclusion that the office has to interpret the statute defining conviction in order to determine whether or not Mr. Sigley was convicted of DUI in this case. Petitioner argues that that's also not true, that the office simply cannot have the power to interpret statutes because it's neither expressly granted by statute nor implied in any power that the office has. But flatly, both of those arguments are incorrect. The office's procedural statute defining how it conducts its hearings expressly charges the office's hearing examiners with making findings of fact and conclusions of law. Statutory interpretation is a question of law, and frankly, the inquiry could end there. DMV's argument turns on a very narrow distinction that the office does not have the power to interpret statutes, as presenting that as a distinct type of legal analysis that the office is precluded from engaging in. But that's such a precise and illogical distinction that there would be no way for the office to function if that were indeed a limit that the legislature had placed upon it. And in fact, the nature of that distinction is such that the court, if it disagrees with the textual basis for allowing the OAH to enter statutory interpretation judgments, there's still a strong basis to conclude that that power is reasonably, necessarily, and fairly implied in the power to hear appeals and make conclusions of law. This court held expressly in Walker v. West Virginia Ethics Commission that agencies have, in addition to any power granted by statute, they're implicitly granted any power that is necessary to render a full and complete decision on the matters which it is statutorily empowered to decide. The Reed case identified by petitioner does not speak to this question. That deals with where an entity is charged with the power to make a decision, doesn't have the power to remake that decision, to make that decision twice. But here we're faced with questions and decisions that the office has to make in order to rule upon the question that's before it. And the substance of DMV's arguments here, in fact, highlight the fact that the office's cases turn on questions of statutory interpretation. If the office didn't have the power to interpret statutes, then its conclusions of law would simply have to be rote regurgitations of whatever statutory arguments the DMV offered in its license revocation proceedings. One clear example of this is the argument petitioner has emphasized here today. The argument that Mr. Sigley's, the fact that Mr. Sigley signed a guilty plea means that he has been convicted of DUI. There's a question whether a plea that is signed is entered or whether a plea that is accepted by the court is entered. That is a statutory question. The revocation statute defines conviction based on whether or not a plea is entered. And the only basis for revoking Mr. Sigley's license here would be the fact that he is named in a judgment of conviction. That's the question that has to be decided by the OAH, whether Mr. Sigley is named in a judgment of conviction. And we don't know that if we don't know whether he was convicted or not. If there's been no conviction, as Justice Hutchinson pointed out, there can't be a basis for revoking his license. However, that
isn't the true issue in this case, whether or not the Circuit Court of Kanawha County got it right and said this is not a case for prohibition, and that it should be sent back and allowed to develop at the OAH level so then it could be appealed.
Yes, Your Honor, that's correct. And that's the exact question that the OAH should determine when it conducts a hearing, whether a plea was entered or not, whether a conviction occurred or not. The DMV's arguments essentially turn on the notion that there can't be that determination. The DMV made similar arguments before the office. It does not advance them here, but they are a starker example of why the office necessarily has the power to interpret statutes when deciding whether to hold a hearing or not, which is the core threshold question here, as Your Honor points out. Appearing before the office, the DMV argued that Mr. Sigley's deferred adjudication agreement under Chapter 61 should constructively be treated as though it were a deferred adjudication under Chapter 17C. A deferred adjudication under Chapter 17C would have waived Mr. Sigley's right to a hearing, and there would not have been jurisdiction to hold a hearing if that had been the case. But in making that argument again, the DMV was asking the office to put a thick interpretive gloss over the text of its statutes. The text of the statutes speak very clearly that a driver waives their right to an administrative hearing when they elect to participate in deferral under this section, under Section 17C 5(2)B. Mr. Sigley did not do that. The DMV initially wanted the office to interpret the statute in a way that would cover Mr. Sigley's deferred adjudication agreement. Once the office did not do that, once it ruled against DMV, DMV argued that the office did not have the power to do that. It has to agree with the DMV. But that premise simply can't be reconciled with the office's nature as an independent appellate tribunal. If there are no questions on that point, I will briefly address the waiver argument that the office raised in its briefs before concluding. The DMV did not couch any of its arguments to the circuit court in terms of the office's jurisdiction. It's raising jurisdictional challenges for the first time here on appeal. And I make this point at the end of my argument because DMV's argument is not the traditional or the typical type of jurisdictional argument that comes before this court. Typically, this court hears cases on direct appeal, and jurisdictional arguments can always be raised in the direct appeal context because in that context, jurisdiction is a threshold determination. If the court below didn't have jurisdiction to decide the merits of a case, then the merits are irrelevant because neither that court nor this court can pass upon the merits of that case. But this isn't a direct appeal, and there's no question that this court has jurisdiction over this appeal from petitioner's collateral attack. There's no dispute that the county court had jurisdiction to hear petitioner's collateral attack. Their jurisdictional arguments against the office are simply one argument of several supporting the merits of their collateral attack. Without that threshold jurisdictional concern, the question here is simply whether ordinary waiver principles apply to bar petitioner from raising a new merits argument on appeal. This court did note in State v. Young that it typically does not entertain merits claims that are raised for the first time on appeal in the context of appeals on collateral attacks. It did not, and I will be clear, it did not decide that with respect specifically to a jurisdictional argument. And given that waiver is ultimately a matter of discretion for this court, this is not a pure matter of law, but as a matter of practice and principle, it would make sense to apply ordinary waiver principles to the jurisdictional argument petitioner is attempting to introduce here on appeal. Applying consistent ordinary waiver principles on appeals from collateral attacks would encourage precision and encourage consistency when these attacks are made at the circuit court level. In this case, we have DMV making first its argument about deferred adjudication when it appears before the office, then attacking the office's powers when it appears before the circuit court, and now attacking the office's jurisdiction when it proceeds on appeal from its collateral attack. These aren't the sort of evolving tactics that would be allowed in the context of other extraordinary writs. Habeas petitioners are held to very high standards for consistency and precision, and it would be reasonable, if nothing else, to hold all petitioners to that same high standard. In conclusion, Your Honors, I'll simply note that the office is winding down its operations. Earlier this year, Senate Bill 130 transferred the office's adjudicatory responsibilities to the circuit courts. But at least for purposes of Mr. Sigley's appeal, for purposes of the few other appeals remaining on the office's docket, and for purposes of all other appellate administrative bodies, this court should not adopt a holding that allows one litigant to dictate what the law says to an entity that the legislature charged with making independent conclusions of law. Instead, it should simply apply the statutes as written, affirm the circuit court's decision that allows the Office of Administrative Hearings to carry out its core function, to hold an administrative hearing, and to make its own independent conclusions of law.
Thank you.
I have just a short point on rebuttal. The OAH makes independent conclusions of law in a DUI case based upon the revocation, the DUI information sheet revocation. They have to look to 17C5A2F to make specific findings of fact and conclusions of law. Those don't apply in this case. This is a 17C5A1A revocation, a revocation upon conviction. The only conclusion of law that they could make here is whether the person named is Mr. Sigley. There's never been a dispute. Under 29A 52B, it has to be a contested case before the OAH. He's never contested that he's not that person. So the DMV's position is those findings of fact and conclusions of law are limited to the sole issue of whether Mr. Sigley contested that he was not that person named and whether he, in fact, was the person named in the plea agreement. His hearing request form...
Is it your position, then, that the DMV has the sole authority to decide whether or not a conviction occurred?
Your Honor, in this matter...
No. Is it your position that the DMV has the sole authority to decide whether or not somebody was convicted, and then the only challenge can be, I'm not that person? Because what you're saying to me is, DMV files and says you're convicted, and you're saying the only avenue of challenge is, I'm not that person, instead of, wait a minute, I was not convicted, and I'm not the person who was convicted.
And our position is, in that case, it would be the Circuit Court of Kanawha County in a writ of prohibition filed against Mr. Sigley to tell the DMV that they were not did not revoke him upon conviction properly.
So even if Mr. Sigley had filed an appeal, he could not challenge DMV's finding that he was convicted. He would have to go to the Circuit Court of Kanawha County to say, I was not convicted.
Yes, Your Honor.
So DMV does make the decision as to who was convicted. That's your position.
That's our position.
Thank you.
Thank you.
Thank you. This case will be submitted.
The next case for oral argument is also under Rule 20, AC&S Incorporated versus Jeffrey R. George, docket number 19-0459, an appeal from the Circuit Court of Putnam County, West Virginia. And counsel, I would like to let you know that although Justice Workman is not present here in the courtroom today, she is viewing and listening to the webcast, and so she will participate in the oral argument, in the decision and opinion in this case. We have provided a clock there on the council table for you to monitor your time for argument, which is 20 minutes for each of you to argue per side.
And counsel, if you, to both of you, when you're addressing the court, you may leave your mask on or remove it at your discretion.
Thank you, Your Honors. Good morning. May it please the court, my name is Ari Spitz. I'm a lawyer at Dinsmore & Scholl. I represent AC&S Incorporated, the petitioner in this matter. We're here today on my appeal of the Circuit Court's denial of my motion to refer this matter to arbitration. What makes this case a little bit unique is the fact that the arbitration clause at issue is contained in a collective bargaining agreement. And the U.S. Supreme Court's case law and opinions concerning how to interpret and apply the scope of an arbitration agreement contained in a collective bargaining agreement has evolved over the course of time. And the Circuit Court in this case applied the standard that was utilized in 1998 by the U.S. Supreme Court in the Wright versus Universal Maritime case. And for two very clear and specific reasons, it was inappropriate for the Circuit Court to do so. Reason number one, in the Wright case, the U.S. Supreme Court specifically excluded from its analysis whether or not the Federal Arbitration Act and the case law under the Federal Arbitration Act should impact how to determine the scope of the arbitration clause at issue. It is in footnote 1 to Wright. The Wright case is 525 U.S. 70 on page 77, footnote 1. The U.S. Supreme Court specifically states, the parties in this case have not argued the applicability of the Federal Arbitration Act, and as such, we decline to consider the applicability of the FAA to the present case. And so in Wright, analyzing only the Labor Relations Act, the U.S. Supreme Court said, there is no presumption of arbitrability in a collective bargaining agreement under the Labor Relations Act. And as such, in order for employment discrimination claims to be subject to an arbitration clause contained in a collective bargaining agreement, the arbitration clause must explicitly include employment discrimination claims. That analysis was done with the specific absence of application of the Federal Arbitration Act. In 2018, the United States Supreme Court issued its opinion in the Epic Systems versus Lewis case. And in that case, the U.S. Supreme Court made clear that the National Labor Relations Act does not express approval or disapproval of arbitration. It does not mention class or collective action procedures. It does not even hint at a wish to displace the Federal Arbitration Act. That's 138 Supreme Court 1612 on page 1624. And so the United States Supreme Court has made it clear that the Federal Arbitration Act does apply to collective bargaining agreements. And as such, when assessing the scope of an arbitration clause contained within a collective bargaining agreement, Courts must apply the United States Supreme Court's precedents concerning how to apply the Federal Arbitration Act to an arbitration clause. And that is that questions of arbitrability must be addressed with a healthy regard for the federal policy favoring arbitration. The Arbitration Act establishes that as a matter of federal law, any doubts concerning the scope of arbitratable issues should be resolved in favor of arbitration. That is the Mitsubishi case from the U.S. Supreme Court, 473 U.S. 614, on page 626. In this case, the case before you, in which the parties, specifically me, has argued application of the Federal Arbitration Act to this collective bargaining agreement, the court must apply the act to the agreement pursuant to the EPIC systems precedent of the U.S. Supreme Court, and in doing so must apply the analysis that I've just read, which means that when looking at the scope of this arbitration clause, doubts are to be resolved in favor of arbitration. The second reason why it was inappropriate for the circuit court to apply this standard, the 1998 explicit agreement standard, is because the case law upon which that standard relies is the Gardner-Denver decision, which is a 1974 case from the U.S. Supreme Court, which was issued at a time when the U.S. Supreme Court's view on arbitration provisions was hostile. At that time, in 1974, the U.S. Supreme Court felt that arbitration was an inferior forum to the judicial process. And the U.S. Supreme Court's views have evolved on arbitration. And that evolution is specifically discussed in the Penn Plaza case, which is a 2009 case from the U.S. Supreme Court. The specific site, I can't read to it. The specific citation is 556 U.S. 247. And in Penn Plaza, the U.S. Supreme Court stated, and it's in footnote 8, because today's decision does not contradict the holding of Gardner-Denver, we need not resolve the stare decisis concerns raised by the dissenting opinion. But given the development of this court's arbitration jurisprudence in the intervening years, Gardner-Denver would appear to be a strong candidate for overruling.
So even if we were, inclined to take a look at Penn Plaza to guide what we're doing in this case, don't you have a bit of a problem relying on it based on the language of the collective bargaining agreement in that case? I mean, the contrast is you have a collective bargaining in this case, which does not address discrimination at all, correct?
Correct. The word
discrimination does not. I searched it. I couldn't find it. You can correct me, but I don't see the word discrimination in there. And in Penn Plaza, there was a fairly clear articulation of the arbitrability of discrimination claims.
Yes, ma'am.
So I appreciate what you're saying about Penn Plaza and the comment, albeit in dicta, about Gardner-Denver, but it seems like that's kind of a stretch to pin your hopes in this case, even if we accept your argument that we shouldn't use the right standard of clear and unmistakable. Where is there ambiguity in this collective bargaining agreement for you to have the argument that the statutory claims here are subject to arbitration? Long question. Sorry about that.
I don't think there is an ambiguity.
4 separate sections.
I think the arbitration clause, and there are 2 arbitration clauses, so I'm talking about the one that pertains to discipline. Mm-hmm. There is no dispute that Mr. George's causes of action arise out of the discipline that AC&S took against him, which was the termination of his employment. And his position is that termination was improper because it was done for it was motivated by an illicit discriminatory reason. And so there's a dispute over whether or not the disciplinary action was proper. And that's what the second arbitration clause requires to be arbitrated. Any dispute that arises out of the employer's disciplinary actions against an employee. Does that answer your question, Your Honor?
Yes.
Is that Article 10 or 11?
Your Honor, it is Article 10, Section 2. It's on appendix page 54.
And what application is the Article 12 that, again, sets forth the arbitration procedures relating to issues relating to interpretation or application of the provisions of the agreement? Is it your contention that it's that the ambiguity or lack thereof, you suggest it is permissible? That's under Article 10 and not 11? Or do you think under both?
I think that it's under Article 10 and not 11 because Article 11 specifically says this is limited to only disputes that concern an interpretation of the agreement, and this dispute is not limited to that. It involves a disciplinary action. And to the extent the court has a concern as to whether or not the scope of the arbitration clause that says disputes that arise out of disciplinary actions is broad enough to include an employment discrimination claim, that question is resolved by application of the Federal Arbitration Act, which says that any doubt or dispute regarding the scope is to be resolved in favor of arbitration. And we now know that the Federal Arbitration Act and its case law must be applied to this collective bargaining agreement pursuant to the U.S. Supreme Court's decision in Epic Systems versus Lewis.
But there's nothing in current federal case law that would get rid of the clear and unmistakable requirement in right.
Correct. I concede the point, Your Honor. There is nothing in the case law that gets rid of it. But what is important to understand is that while it is still here, while right is still here and has not been overruled, it doesn't apply to the facts of this case. And what distinguishes it is the fact that in right, the parties did not argue applicability of the Federal Arbitration Act. And in right, the U.S. Supreme Court did not apply the Federal Arbitration Act to the collective bargaining agreement. Today, in this case, at the circuit court level, we have argued application of the Federal Arbitration Act, and that makes this case distinct and not subject to rights holding. Unless Your Honors have any other questions or wish me to discuss any other issues.
Well, I guess I have one other sort of pushback on your position, and that is, you know, you're asking us to, well, backing up. Unlike other arbitration agreements in other contexts, a collective bargaining agreement is a document that is negotiated by highly sophisticated parties, right? I mean, you have a union, you have a company, they both understand, and in my experience, if there's not something stated, it means that one party or the other couldn't get it. Does that simple fact, should that simple fact inform our interpretation of this document?
Your Honor, I may not perfectly answer it, and if so, I apologize.
There's no grading scale for your answer.
I view that question as a question about what are the expectations of the parties when they form this contract.
That's fair.
And the U.S. Supreme Court, in the Wright case, said, well, we assess the parties' expectations based upon the application of the law. And in the absence of application of the Federal Arbitration Agreement, the expectation is not one that involves a presumption as to the scope of arbitrability of issues. Okay? And that's in Wright. And that's why in Wright they said, since there's no presumption here, you got to have a clear and explicit agreement. But with the application of the Federal Arbitration Act, the expectations of the parties are that the Federal Arbitration Act applies and that the collective bargaining agreement will be interpreted in accordance with the precedents of the U.S. Supreme Court's analysis of the Federal Arbitration Act. And so the presumption is that the arbitration clause at issue will be construed liberally in favor of arbitration with any doubt as to its scope being resolved in favor of arbitration, which I hope answers your question.
It absolutely does.
All right.
Thank you, Your Honors.
morning, Your Honors. May it please the Court. My name is Jesse Forbes. I'm here on behalf of my client, Jeff George, who was part of a collective bargaining agreement that's been mentioned thus far and that has very specific terms in it. And the terms in that collective bargaining agreement do not clearly and unmistakably make a case that this type of claim would go to arbitration. It's simply not in the agreement. And I want to jump right into some things that my opposing counsel mentioned, in particular with respect to the Wright case. Wright was unanimous. In 1998, it was authored by Justice Scalia. It has never been overruled. And essentially what they're urging this court to do is overrule the United States Supreme Court and federal circuits throughout the land with respect to a collective bargaining agreement.
What about counsel's point that that case didn't involve the Federal Arbitration Act?
I don't think that's accurate when you read the case. The footnote that he cited actually begins with, we, authored by Justice Scalia, footnote 1, page 77 of Wright, we have also discerned a presumption of arbitrability under the FAA. And they cite to Mitsubishi, which he just cited to. Justice Scalia went on in the Rent-A-Center case years later in 2010 to show you why there's a distinction. The reason that Wright doesn't focus on the FAA is that that has to do with the validity of arbitration agreements. We're not contesting that this arbitration agreement is valid with respect to discipline. The issue is that and this is touched on in Rent-A-Center and discussed in 2010 in the Rent-A-Center case that's in the briefing, that there's a difference between validity and intent. And the intent of the contract here did not mention discrimination. It didn't get into anything that changes the clear and unmistakable standard, which has been applied throughout the Fourth Circuit, other circuits, and the U.S. Supreme Court. So my issue with the representation that Wright is no good now because it didn't address the FAA is that I think he's comparing apples to oranges. We are not challenging this arbitration agreement. We're not saying it's invalid. It is perfectly valid. The problem is that his clients who were a party to it didn't get language in it that supports their position today. If that language was there, I wouldn't be here. We had a circuit court order that clearly, based on the precedent federally and what this court has said before, that arbitration should be presumed if it's in the contract. The problem is that it's not in this contract. There is nowhere in this contract that addresses discrimination and the claims that were brought here. The Wright case is specifically on point because it's almost the exact same situation. What Justice Scalia was faced with there and the unanimous United States Supreme Court was faced with there was a situation where there was an arbitration provision that had to do with wages, hours, terms and conditions of employment would go to arbitration. And the United States Supreme Court found that that wasn't enough. Frankly, I think that's more in an arbitration provision than what you've got in this case. And to touch on your point, Justice Walker, the circuit court mentioned the same concern over trying to read things into this contract that weren't there. And the circuit court at that level said, this agreement was signed in 2014, and it was signed between the parties then, well after the case law where they start to address whether arbitration should be more readily used and more weight put on it. The court there had discomfort with saying that we're going to write something into this contract that's not there, and you should have that same discomfort. Essentially, what my opposing counsel wants you to do is based on a footnote in Wright, and now a footnote 11 years later in Justice Thomas's opinion in the Penn Plaza case in 2009, he wants you to look at footnote 8 in that case and say that the Supreme Court now disfavors the holdings that buttressed the Wright case. That's not true. If you actually look at footnote 7 and read it with footnote 8 in the Wright or in the 14 Penn Plaza case, it makes it very clear that what was happening is that was a response to Justice Souter's dissent. And what they were saying is if you believe that the dissent thinks that the Gardner-Denver case from 1974 that holding is what the dissent believes it is, then our court should overturn that. It's complete dicta, and it's not even saying the court should overturn it. It's saying if you would believe what the dissent is saying. I mean, essentially, it would be like me going to a circuit court 5 years from now and trying to say that a footnote in one of your decisions 3 years later where you specifically didn't overrule a prior case now overrules the law of the state. It's ludicrous, in my opinion, to say that you can hang this on that. It's not just my opinion. Frankly, it's also Justice Scalia's opinion. There's a quote from him in 2015 in a concurrence where he stated, dicta, even calculated dicta, is nothing but dicta. That's what you don't even have dicta here. You've got footnotes. And the footnote did not say they were going to overrule Wright. In fact, that case relies on Wright, the 14 Penn Plaza case. And I think that case specifically shows why this collective bargaining agreement doesn't have the same terms in it, because in that case, there was specific language that discrimination claims would go to arbitration. In our case here, we've got the section that you pointed out, Justice Jenkins, that counsel has conceded doesn't apply because it says that it only applies to things involving the contract, and it's just a general provision. And then they're trying to hang their hat on this argument that because disciplinary issues would go to arbitration, that covers this agreement, or that would cover sending this case to arbitration. It didn't in Wright, which actually had stronger language. It hasn't since then, and the Fourth Circuit has made it very, very clear when they've looked at this that you've got to have one of two ways that you go to arbitration under a collective bargaining agreement. You either have a catch-all that says any action whatsoever related to the employment, everything, goes to arbitration. We don't have that here. That's conceded. The second provision is what matters. And the Fourth Circuit, Carson v. Giant Food, it's in the briefing, a 1999 case, has said that otherwise you've got to have in the CBA, it explicitly incorporates anti-discrimination laws, and you have to make that unmistakably clear. It is not unmistakably clear here. It's not in the agreement. The simple solution here was, frankly, they should have had either better lawyers or more people looking at this at the time they wrote this agreement. They didn't do that, and they didn't get it in the agreement, and this collective bargaining agreement does not contain provisions that send this to arbitration.
So as you mentioned, petitioners are relying on the language in Article 10, which is the agreement that the sole remedy for disputes regarding disciplinary actions is arbitration. And we're setting aside the debate about whether we're talking about the right standard or not, just looking at the agreement for a minute. Does that completely subsume the complaint in this matter? In other words, I'm reading, I'll tip my hand and just ask you to comment on it. I'm reading you that the plaintiff has also asserted a failure to provide reasonable accommodation under the Human Rights Act. Was that related to a disciplinary action as well?
It's not related to the disciplinary action because it's not specifically included in that. The disciplinary action was his termination, where he contended that they let him go for supposedly violating a safety standard in the plant. He actually filed a grievance over that and lost the grievance. He didn't pursue that. What he's claimed, and he has not specifically claimed anything regarding discipline, he's claimed regarding statutory provisions. And what the federal law says is if you're going to make those claims on statutory provisions, you go to a judicial body. You don't go through arbitration unless the agreement specifically addresses those anti-discriminatory claims. This agreement did not. It doesn't have it in there. And I think you have to read it in conjunction with Wright and the federal case law because that's what governs collective bargaining agreements. And in the Wright case, they were faced with the exact same situation. In that case, you had a situation where there was nothing in the agreement about discrimination. There was nothing saying those types of claims would go to a arbitration. And instead, what you had was a situation where things regarding disputes over the employment would go through arbitration, not where someone violated state statutory law. And that's all we've alleged in the complaint in this case.
But aren't you, just flipping things around a bit, aren't you asking for two bites of the apple on your argument? I mean, your client went to arbitration, lost, and now you're seeking another way at it. Why why in the context, again, of a collective bargaining agreement your client was represented by a union who, obviously your client would have remedies against the union if your client didn't believe it protected his interest. But why should he get a second bite of the apple in this case?
I don't believe he's had a first bite, Your Honor. So first, he didn't go to arbitration. What he did with his union steward was file a grievance over the firing. Never went to an arbitration process. And in that grievance, he essentially challenged the contract itself. And it's actually listed in there that he was challenging his firing under the contract. There was a catch-all in there that he checked off and said, and any applicable state and federal laws, but he never made a claim for discrimination, for failure to accommodate, or any Harless-style claims. He didn't bring those in the grievance procedure, and he didn't go to arbitration. He went simply to the grievance procedure on the underlying issue involving the contract. This is something outside of the contract that they want to write into that agreement, and it's simply not here. And frankly, they're asking you all to rewrite this contract from the bench or to overrule the United States Supreme Court. Those are the two things that I believe they're asking you to do here.
If we look at this, step back and take an overarching look at it, effectively Scalia said in Wright, look, we understand that the federal law presumes arbitration is the appropriate way to go. But what you've got here is you've got an agreement that is the result of collective bargaining. And so when you get down to the very independent personal rights of guys that were not involved in that bargaining process, then it's got to be very clear and unmistakable that those individual, really personal rights have got to be made part of this arbitration agreement, or we're going to protect the individual over the agreement. Is that effectively what the whole, because Penn Plaza says the same thing. I mean, they spend a lot of time in Penn Plaza talking about the fact that discriminatory actions were included in the contract.
Right. No, I think that's exactly it, Your Honor.
Is that the umbrella that we're working under here?
I think it is, and I think that's the idea is that because this is bargained on behalf of these individuals who have statutory rights and have substantive common law rights, you've got to clearly and unmistakably bargain those away. And they didn't do that here, and that's what the United States Supreme Court has said. Justice Scalia has said. It's a unanimous decision from 1998. It's not. This was not some 5-4 decision. This is unanimous. It's never been overturned. The entire point from the other side is that a footnote talking about another case that, frankly, Justice Scalia, in his opinion in Wright, said there's two tracks to get here. One of them, he talks about the Gardner decision, but he talks about the Gilmer line of cases too. It's never been overruled, and that footnote in the Penn Plaza case does not overrule a unanimous Supreme Court from 10 years before. It just simply doesn't. Read footnotes 7 and 8, and I don't understand how they can, with a straight face, say that footnote suggests that the Supreme Court thought they were going to overrule it. It doesn't. It goes back to your point, Justice Hutchison, that this is a situation where his rights were not bargained away with respect to statutory provisions. They could have been. And if they were, we'd be in arbitration. But that's not where we are. And they're asking you all to make a leap of some kind of overturning federal precedent that's been in place for 20-some years and United States Supreme Court decisions. And I just don't think it's in any way supported in the record of this or under this collective bargaining contract. If anyone doesn't have anything further, I think that's it for me.
All right.
Thank you.
Thank you.
We're not talking about giving up statutory rights. We're talking about being required to pursue those rights in arbitration form or in a judicial form. And the right when the union is negotiating, if they're going to negotiate over where an employee has to bring a lawsuit, there's got to be an explicit agreement. That is the analysis under the Labor Relations Act in the absence of application of the Federal Arbitration Act. And I'm going to read most of the footnote just to make it clear, because I think it's been not stated clearly by my opposing counsel. In footnote 1, to right, the court writes, after reading that opening sentence, petitioner argued that the FAA does not apply in this case, and the respondents have not argued otherwise. In these circumstances, we decline to consider the applicability of the FAA to the present case. So yes, this footnote, footnote number 1, clearly, specifically says the right decision is being made in the absence of application of the Federal Arbitration Act. And then we get the Epic Systems versus Lewis case in 2018, where the U.S. Supreme Court says the National Labor Relations Act has no impact upon and does not in any way, shape, or form displace the Federal Arbitration Act. That pronouncement, which is at page 1624, the citation is 138 Supreme Court 1612, page 1624. That announcement is critical to the court's determination of what standard should be applied in this case to determine the scope of the arbitration clause at issue. And Your Honor, with respect to what they alleged in the complaint, yes, they did allege failure to accommodate, but it was failure to accommodate in the context of termination. In other words, instead of accommodating him, they terminated his employment. And the act of termination, there's no dispute in the record. It's on appendix page, if I could have one moment, sorry. It's on appendix page A73. The termination was a disciplinary action. And as such, it's subject to the arbitration clause. Finally, Your Honor, you asked about what did he submit to the grievance. He included, and he wasn't required in the form to do this, he wrote it in, that his termination violated applicable state and federal laws. And the grievance procedure leads to the arbitration in the context of this collective bargaining agreement. The procedure is you file the grievance. If the employee files the grievance, the employer has so many days to respond. If the employer fails to respond, then the employee can escalate. And after, I think it's one step of escalation, the result is the employee is permitted to have an arbitration. So there's a process, right? So Mr. George submitted the grievance. He could have then continued to pursue it, including his contention that his termination was in violation of state and federal laws, but he chose not to. And so, Your Honors, unless you have any questions for me, I respectfully rest. Thank you.
Thank you. This case will be submitted.
All rise for the next statement.
Hello, everyone. It's October the 7th on Wednesday. Regretfully, again, I've got to report to you that we've lost 8 more additional West Virginians since Monday. Our 362nd death was an 82-year-old male from Kanawha County. Our 363rd death, a 64-year-old female from Cabell County. 364th death, a 72-year-old male from Cabell County. Our 365th death, a 56-year-old male from Kanawha County. Our 366th death, a 65-year-old male from Kanawha County. Our 367th death, a 67-year-old male from Wyoming County. Our 368th death, a 72-year-old female from Harrison County. And our 369th death is an 81-year-old male from Fayette County. Oh, I sound like a broken record, don't I? But it is so important to me and my family, Kathy, all of us, and all West Virginians that these people, these great West Virginians, don't become just a number. You know, please keep all these people in your thoughts, your prayers, thinking of them, thinking of all their families, all their friends, all their loved ones. It's a catastrophe beyond all of our abilities to comprehend. A pandemic. None of us would have ever really thought it was possible, but it's here and we're getting through it. There's so many of our indicators that are better, but it's still tragic to these people. So please, like I said, always keep them in your thoughts and your prayers. Now, I want to just say this too, that, you know, one of the great people that works with me every day is Jordan Dameron. And he just walked up and he just told me, this is our 134th briefing that we've had. You know, it's just unbelievable. And when you think back and think of this, that we've lost 369 great West Virginians now. We've done 602,802 tests on West Virginians. We've been through an incredible amount, and I thank you for giving me the strength and your trust. We're going to get through this. We're so much better than everybody around us, and we knew going in that we were the most vulnerable of all. From the standpoint of the economic side, we're so much better than anyone around us. It's unbelievable. And we keep on just keeping on. So West Virginia, you're superstars beyond belief. I love you with all my soul. And sure, we are dealt a tough hand and a cannonball right to the stomach, but we're going to get through it. We're getting through it. We've got great, great West Virginians we've lost, but we're going to win the war. Surely we have problems in the battles, but we're going to win the war. And for that, I hope and pray we always remember all those we've lost and all those that are helping so much. We have a nurse's death that we have that we've learned about just a little while ago, that a nurse at the Ruby Memorial Hospital in Morgantown has now died. In addition to that, we have a death of an employee that was a nurse at the Bateman facility for more than 10 years. And I want to make sure that I get this right, but also an employee of the Mildred Mitchell Bateman Hospital has died as a result of this. Bateman is located right outside of Huntington and has it is one of our 2 psychiatric hospitals in the state. This employee was a nurse and worked at Bateman for more than 10 years, as I said just a second ago. We should continue to remember all these first-line responders. These are the real heroes. Now we have lost 2 nurses within our state, and just imagine that if you were one of these great people and you get up this morning and you know you're going right not to the fire, you're in the middle of the fire. And you know you come home, your family's there, and all their loved ones, all your friends. You've got to protect yourself to the very best of all of your abilities and everything. But even with all that level of protection, we still lose our great heroes. You know, just the other day, and I'll mess this number up, but I think they were paying tribute to 60-some odd, or it could have been 40-some odd, policemen in New York City that have died from really COVID and absolutely trying to do anything and everything they could to try to help people. That's what these people do. They know the job is dangerous when they take it. And they know that there's trials and tribulations that they're going to have to go through, but they never, ever thought they were going to have to sign up for a pandemic. So absolutely, these are true heroes, and please, please keep them close to your heart as well. We've had 203 new positive cases in the last 24 hours. Our daily positivity rate is 3.27, from yesterday. Our cumulative positive rate is now at 2.77. We still have just a little over 4,000 active cases and right at 12,500 recovered cases. We have 168 people that are hospitalized, and our reproductive number, our effective reproductive RT number, is at 0.83, which is now the second best in the nation again. And that's really, really, really good stuff, because that means whatever we're doing is working from the standpoint of our mask and our testing and isolating and finding those spreaders and cutting them out and everything. And, it's working. I know we still lose people, and we're going to get through this some way, somehow there, but what we're doing is working. We have no counties in the red on our color-coded map. We have only one county in the orange, and that's Upshur. And we're working to test more and do everything we can possibly do to help those people in Upshur. And as we test more, what we'll do is just what I have said over and over and over. We will find those that we would not find any other way. And when we find them, we will ask them, or we will some way contact trace. We will isolate. We will help them get well, and we will prevent them from spreading this disease to more and more and more. And we just keep running the same Groundhog Day over and over and over unless we can find the spreaders. So by testing more, test, the more we test, the more we'll know, and the better off we'll be. Today we're going to be in Upshur County, with doing additional free testing. I encourage everybody in the county to come out and get tested today, because it will help not only you, it will help all of us to find out information. If we just pick up one spreader, we'll be able to stop this thing right in its tracks, but we can't do it unless we know. We have 18 outbreaks in our schools right now, with 50 confirmed cases in the public school system reported by the Department of Ed. You know, again, we continue to handle this in a really, really good manner and everything. And we hope and pray nothing happens that it gets worse and everything. But right now, we keep running to these fires and putting them out. And really and truly, I think we're doing a really good job with this. Our long-term care facilities we have 41 outbreaks in our long-term care facilities right now. We have 13 outbreaks in our churches in 9 counties. Mason and Doddridge are new counties that have joined Upshur, Logan, McDowell, Tucker, Harrison, Fayette, and Kanawha counties. We want to strongly urge what I've said over and over about a pew in between and wash your hands and wear your mask and think really hard if you're one of the elderly about whether or not you should be in church this week or not. And I surely respect your wishes in every way. If you go, protect yourself like crazy. And if not, you can skip a few weeks and everything and get online services or whatever it may be. It may be better. From the correction standpoint, we have 4 cases that are active only now. We have 2 at Mount Olive, 1 at North Central and 1 at South Central. And the guard is back, doing additional sanitation missions in different places as well. From the flu vaccine, get your flu shots. It's the only smart thing to do. Get your flu shot, please do. It's painless. There's nothing to it at all. I mean, just get your flu shot. From the standpoint of the CARES money, it's going out to the cities and counties. We've now sent out $140,347,049.39 have been awarded to the cities and counties. We continue to ask them, continue to apply. We're going to continue to send the money. From the standpoint of the census, we're at 99.9, tied for first place in the country. Way to go, West Virginia, way to go. Now think about this. 3 years ago in West Virginia, we went to the polls, did we not? Now it wasn't the polls, to elect individuals, to the statewide offices or to our legislature or whatever it may be. This was a special election. It was our Roads to Prosperity Amendment. It basically was the road bond referendum. Now, I very, very, very proudly can say that, I ran myself ragged, going all over the state, talking to a lot of people and doing town halls, and I had 1 million questions and everything, and most of the questions centered around, well, we've heard this stuff before, but what happens is after the fact, then our taxes go up like crazy and our roads never really get built. Well, that's surely not what's happened here. And so on this 3rd anniversary, I think we all in West Virginia should share in a celebration and a real celebration. We have now got over $1 billion of major infrastructure improvement projects that are underway or finished, and I just can't say enough about just this. West Virginia, naturally it takes a leader. It takes someone to come up with an idea. It takes a legislature to pass and act on that idea. And then we really turn the ball over to you, don't we? Well, when we turn this ball over to you, in a lot of different situations, this bond would have been defeated. It took a lot for you to really believe that this was real. It took a lot to believe that there would be thousands of miles of roads that would be either built or improved upon or ditches pulled or all these crazy potholes taken care of and everything. It took a lot to really believe and trust in this. And then go to the poll and get out and vote. And 73% of you voted in favor of doing this. So really and truly, West Virginia, You know, it took somebody to come up with an idea, and it took a legislature to pass it. But at the end of the day, West Virginia, you deserve the credit, and that's great with me. It's always great with me. You deserve the credit for all the great work that's happened and continues to go on. And so today is a really special day, a special day for our roads to prosperity. Now, the other thing I'd like to report just real quick is we continue to do great work on broadband in our state, and we've got hopefully some really more exciting announcements to make in the next few days or the weeks to come, and we're just going to keep at it. You know, I congratulate Kanawha County today. I just saw this just a few seconds ago or minutes ago, but Kanawha County has now gone from blazing red to gold. We thought, my gosh, how good. We went from red and hot as a firecracker to orange, and we just couldn't get out of the orange and everything. And then all of a sudden, lo and behold, we drifted into gold. Fantastic Kanawha County, but today you're in the yellow, and that's really, really good. So keep it going, Kanawha County. We're going to get these numbers down. We're going to get this infection down, and we're going to shut this thing down, not only in Kanawha County, but we're going to shut it down all across our state. Again, remember all those we've lost in your thoughts and prayers, and let's just stay at this. That's all I got.
All right, thank you, Governor. Let's first today go to Dr. Clay Marsh, our coronavirus czar.
Well, good afternoon. I want to also talk just for a second about the strategy we're taking for the public health map that we're publishing, that we're using also for the schools. I just want people to remember the reason why we have added at the governor's challenge to us, added the percent positive rate to the incidence rate. People have been reaching out and have been saying, why don't you just use the infection rate like we have seen from sources like the Harvard Global Health Institute? And that's a really important metric to use in public health settings. But as you remember, what happened is that that rate only counts the number of positive cases we have each day on a 7-day average, and it doesn't account for how many tests that we did to get to those positive cases. So what people were recognizing, and local health officers, local health departments in counties, were that counties were reducing their testing because the citizens figured out, and a lot of people figured out, that if you reduce the testing, maybe you would find fewer cases. But as the governor has said, the really important cornerstone, the real way that we're going to help West Virginia stay healthy is to identify those few people, that 5 to 9% of people who become infected. And in that 2.5 days or so before infection, up to that day of infection, they can be highly contagious, and they can spread to other people without even realizing they're sick. And they're called super spreaders. And that 5 to 9% of people has been found to infect 80% of everybody who gets COVID. So ultimately, the way to identify them is to test. And that's why we added that percent positive rate. And we used national standards. We chose below 5% to get from that orange color to gold color. But the idea is that we want people to test and test and test. And we have seen that change. As the governor said, our reproductive scores come down. We still see too many West Virginians dying, but that rate seems to have come down a little bit. And our tests are going way up. We've almost doubled the number of tests after we've changed the metric. And for counties like Kanawha County, as the governor said, it provides an incentive for them to get tested so that they can bring those numbers down. And because we are testing more and identifying some new people, which is so important, because if we can identify some of these super spreader people, then we can really substantially impact positively the health of West Virginia. But what we will see initially is the infection rate will go up. The Harvard metric will go up because we're identifying more people. But as we can get those people isolated and not able to infect others, then we know that over time that infection rate will come down too. So what we're really looking for is we're looking for an approach, as we have continued to evolve our strategy, to be able to test a lot, to be able to identify people who could be super spreaders, isolate them using contact tracing, reduce the death rate and the amount of COVID spread in the state of West Virginia and each one of our counties, and then also increase the number of tests that we do and keep that rate overall below 5% and even below 3%, which is even better. So West Virginia, we are working hard to try to make sure that we are providing the right tools for people to be able to be safe. And again, this map is not done to try to open all the schools. This map and this approach is done to try to reduce the spread of COVID-19, which makes schools safe, but also which makes West Virginia safe. And thank you for all you're doing to make that happen.
All right, thank you, Dr. Marsh. Next to Dr. Ayn Amjad, our State Health Officer.
Good afternoon. We've gotten reports from a lot of local health officers that they have noticed some other signs and symptoms that people have reported for COVID-19, that it's not just the fevers and the cough and shortness of breath that people have reported. They're also noticing people have had symptoms such as allergies or body aches or general symptoms of just not feeling well. So we encourage everyone out there that if they're having other symptoms, even the loss of taste or smell, or even allergy symptoms that are not your normal, to go and get tested. This is another reason why we have ramped up our testing across the state, that it is available to everyone nowadays, and that we are seeing these super spreaders or people that are not normally having the symptoms that they have during this season to go and get tested. Because as Clay mentioned, there are people who are having these symptoms or asymptomatic spreaders out there that are causing these cases that we are seeing. So we encourage everyone to not just look for those symptoms of a high fever or shortness of breath to get tested, because our local health departments are reporting these cases to us. Thank you.
Good, thank you, Dr. Amjad. Next to Bill Crouch, Secretary of the West Virginia DHHR.
Thank you. Good afternoon, everyone. As the governor mentioned, we are sad to report that an employee of Mildred Mitchell Bateman Hospital has died as a result of COVID-19. This employee worked at Bateman for over 10 years. She was a wonderful mother, daughter, and coworker, and she received many accolades for the outstanding job she did at Bateman. So it's always difficult when we lose West Virginians, and this was one of ours, and we're just deeply saddened. Our thoughts and prayers are extended to the family, and she will truly be missed. Thank you.
All right, thank you, Secretary. And last to Major General Hoyer with the West Virginia National Guard.
Good afternoon. On behalf of the National Guard, we'd also like to extend our condolences to the family of our fellow state worker. We will keep her family in our thoughts and prayers. Today, we received notice that FEMA will allow us to add to our cap of Guard personnel. So we'll go up to 400 employees, Guardsmen, who will be 75% federally reimbursed. That will allow us to increase some additional support to DHHR epidemiology. We'll go up to 70 personnel supporting that effort. Exceptionally important that we continue to support DHHR in that effort. Today, we had personnel in Nicholas County at the request of Secretary Crouch and Dr. Amjad. We're providing some additional support to Nicholas County to address some manpower issues in that particular county. As the governor and Dr. Marsh pointed out, it's about testing and about wearing our masks, and we are going to put a particular focus on supporting DHHR, local health departments, and some new initiatives that we will roll out related to and continuing to ramp up the testing over the next couple of weeks, and disinfection missions continue. I'd like to leave you with two last things related specifically to the National Guard. Unfortunately, today is the anniversary of the 1992 C-130 crash, where 6 National Guard personnel died in a training accident outside of Martinsburg. So we ask that you keep their families and their memories in your thoughts. Also, today marks 20 years since the start of Operation Enduring Freedom. I think it's important to know the role that West Virginia plays, and one of the first Special Forces units in Afghanistan after the September 11th, 2001 attack was a West Virginia National Guard Special Forces company led by some folks who still serve in our organization, but also the commander of that unit was retired General Russ Crane, who now works for DHHR. So we thank those folks for their great work and all the folks who have served over the past 20 years attempting to keep our nation safe. Thank you.
All right, thank you, General. We'll now go to questions from members of the media. The first today from Paul Mullen with WCBC.
Good afternoon, Governor. Good afternoon, panel. With the president testing positive and coming down with COVID-19, have you taken any additional steps to safeguard the staff there around you? And could you talk a little bit about what they have to go through on a daily basis in order to talk to the governor?
Well, Paul, we've taken additional safeguards, that's for sure. We've, around me all the time, that we've tried as hard as we can to just keep real familiar faces around me, and if we have a meeting like we just had, with people that weren't normally around me all the time. Of course, everybody in the meeting always, everybody's wearing masks, and as I go around the state, yesterday I spoke at a couple different places, and I went to Tiger State Park yesterday, and we were able to award, or do a whole lot of renovations and upgrades to not only the lodge, but to roads and the boat docks and all kinds of stuff like that. And so from the standpoint of the governor getting around and going, I surely need to go. It's expected of me to go. I want to go, and I'm going to go. But within all of that, now we've taken extra precautions, from the standpoint of people taking pictures, and they kind of rope off an area, and it's just it's a crying shame, from the standpoint of what we've got to go through. But we better take heed to any and everything we can to try to be as safe as we possibly can. And those things that we do will only lead to others being safe and others not exposed to this dreaded disease, because the bottom line is, if it can invade the White House in the United States of America, it can invade anywhere. So we all need to be super safe. I offer up my apologies for not being able to shake people's hand and hug people, and because I'm that type of person. I love West Virginians. I think they're the best of the best, and so, but right now we've all got to be just as super safe as we can be. We'll get through this. There'll be a vaccine, and there'll be all kinds of times for us to be back embracing one another as we always have. But yes, Paul, we've taken some extra precautions, that's for sure.
All right, thank you, Paul. Next to Brad McElhenney with West Virginia Metro News.
Oh, hi, Governor. Quick follow-up. You had a meeting. What kind of meeting was it? But also, my real question is, the House of Representatives, Congress, passed the latest round of federal relief for COVID in May, and then a revised version of it at the start of October. But there's been no broader agreement yet among the House of Representatives, the U.S. Senate, and the White House. Last night, the president tweeted something that indicated negotiations should stop until after the election. What's your understanding of where matters stand at the federal level, and how important is the latest round of federal relief to West Virginians? Thank you.
Okay, Brad, what was the first part of your question? I got all the rest of it, but what was the very first thing you said?
Oh, you mentioned in passing that, to Paul Mullen's question, you mentioned, well, I just got out of a meeting, which tripped my curiosity about what it was about. That's all.
Well, the meeting was about broadband. We continue to try to work, on that and everything. You'll hear a whole lot more about that in the days ahead or the weeks ahead. But you see, at the end of the day, from West Virginia's standpoint, so many things, and here's how I just see the whole deal. I mean, and this is how I saw the whole thing from the day that I came in the door. First of all, we had to go on an out-and-out campaign to be able to change our image. So the first thing I thought we needed to do was make education our centerpiece. Put a stake in the sand on that. The next thing I think we had to do is we have to have highways. We got to have roads. We can't go to the convenience store and tear our vehicle all to pieces going to the convenience store. And right behind that, we got to have broadband all the way across this state, do we not? And there's so many other things, diversification and tourism and all the different solicitations of business and opportunities coming to West Virginia, all that. But those are three cornerstones, that's for sure. Now, Brad, back to your question about the next stimulus package. The Democrats and Nancy Pelosi have come out, and they came out in the beginning and said, we want to do $3 trillion. The sticking point is really simple. They wanted to bail out a bunch of Democrat states and Democrat counties, or Democrat cities, and I mean Democrat by the leaders of those states, the governors, or the mayors of those cities, had run up these ungodly pension liabilities, and they wanted money to bail them out. And the Republicans are saying, wait a minute, now hold on, stop. We want to be fiscally responsible, and we don't want to just throw money into something where people have mismanaged and not done their job. It's absolutely reasonable in every way. So there's an impasse, boom. And we can't get off get-go. Now the Republicans are at a point in time where the Republicans are saying, we're good with $1.6 trillion. Good heavens to Betsy, and the Democrats are saying, we want 2.2. Now, I really have believed, and it would be more Christmas comes early to West Virginia if there's a stimulus package passed. We don't need it from the standpoint of where we are right now. We have done amazing work with where we are, but we will have need as it goes forward, and there's so many others that are out there that are either lost their jobs or having tough go and everything that we can help. And absolutely so. With all that being said, our president tweeted out the other day, he says he's going to postpone this till after the election. I don't want him to do that, and I do not think that's the thing to do. Because after the election, one side's going to win, one side's going to lose, and whatever side loses, it's going to be difficult on them. And from the standpoint of the lag, the time, you just think, Brad, right this minute, you've got restaurants that are super struggling. You've got all kinds of small businesses that are still really struggling. You've got people that are sitting wondering how in the world they're going to make it because they've lost their job. Their unemployment benefits, their bonus monies and all that kind of stuff is gone. What are they going to do? And so from the standpoint of postponing it, terrible. I just think that's not good. So from the standpoint of a hope in every way, very quickly the president pivoted and said, well, wait a minute here. Let's try again to try to get this thing finished and across the finish line. And I hope to goodness, I don't want to be disrespectful, but what goes on in Washington, good gracious, it's ridiculous. It's beyond all good sense. I don't know how any living human being can make a rational thought out of let's defund our police? How could anybody come up with something like that? But with that, you've got the sides, both Democrats and Republicans alike, and all they want to do is do the next gotcha to the other side. And I see Washington just that way, a gotcha deal. The people don't matter. The people should be the only thing that matters, but they don't matter. Really, it's just the next gotcha move and the next soundbite. So I don't know. I wish to goodness that reason would prevail, but I don't know if the last stimulus package will come this way or not. I sure hope it does, but that's all I can give you as far as the update on all of it.
All right, thank you, Brad. Next to Jade Burks with WVVA.
Good afternoon. This is Jade Brooks of WVVA. This might actually be a question better suited for Superintendent Birch, but for several days here in Mercer County, we've had one or two bus routes that couldn't run because there aren't any substitute bus drivers. Just wondering if this is a widespread issue across the state that we're seeing, and if anything is being done to hire additional personnel. Thanks.
I can answer it, I think, better than anybody else on the call, but let me just say this, and it's not very well. Superintendent Birch isn't here. He can answer it a whole lot better than I. I know we have a critical situation with substitutes, and we're doing everything in the world from being able to let the young people that are in our colleges and everything, from the standpoint they're doing their student teaching, that they could be an active substitute and get paid for it. Our State Board of Education is doing an amazing job recruiting people and everything to try to do any and everything that they can possibly do to fill these jobs and fill this need. But it's a real need and it's a real problem, but they're working on it. That's all I can tell you.
All right, thank you, Jade. Next to Charles Young with WV News.
Hi, this is Charles Young with WV News. Governor, you recently said you were working on plans to get the bars in Mon County back open. Could you give us an update on that and give us an idea of the kind of precautions and regulations that would be in place to prevent a repeat of what happened last time we opened the bars? Thank you.
Charles, I think, we'll have a whole lot more on that on Friday. And I know that my general counsel, Brian Abraham, is in conversation with these people and everything. As far as the guidelines and stuff, all we want is just this, just the level of spacing, the mask, different things that are just the normal protocol. We got overloaded there and everything, but I'm real hopeful that we can move forward with getting those businesses back, because you got employees and you got the same kind of situation. You got business owners, employees that need the job, need to work, and we ought to be able to figure this out, to be able to handle this in a safe manner.
All right, thank you, Charles. Next to Kenny Bass with WCHS and Fox 11.
Thank you. It's Kenny Bass with Channel 8 and Fox 11. Governor, hearing a lot of concern, as I'm sure we all are, from parents and teachers and workers and community members about students being in school, and just not because of numbers or because of metrics, because of maps, but because of not following recommended CDC guidelines. In many schools, and I've got pictures to prove it, they're just not 6 feet apart. There's mask wearing isn't being mandated, it looks like, very seriously or closely. I think Dr. Marsh even said in response to some questions he was asked by people that it's certainly not the best way to go, in a manner of speaking, only spacing students 3 feet apart instead of 6. So if we're serious about this virus, if we're serious about being safe, if we're serious about the government taking away the rights and privileges of people in order to curb the spread and to try to keep as many people as possible not sick and not dead, how can we justify putting kids into schools where they're only sitting 3 feet apart and they're not wearing masks and they're not doing the basic things that we say have to be done in addition to testing in order to curb the virus? Thank you.
Okay, Kenny, let me let me ask you a question back, and then I'll answer your question, and I'll answer it really well, I think. How many people have we lost in the United States? Just rough number. How many people have we lost? How many people have died in the United States of America? Do you know the answer to that? Kenny, can you hear me?
Yeah, Governor, I can hear you.
Did you lose me there? I mean, okay, I'll do it one more time.
I'm still with you.
Okay, how many people do you, and roughly, just a rough number, I know you don't have to have an exact number, but how many people in the United States of America have died with the COVID disease?
The CDC estimates that about 210,000 Americans have died thus far because of the coronavirus pandemic.
Now, the reason for that, and we could go back and forth because, you know, Kenny, I love you to death and we're friends, but we could have a real discussion about this, but I'm just gonna take it from here. But Kenny, the reason that both of us know that 210,000 Americans plus have died is one thing, and that is our freedoms in this country lead us to being, in some ways, surely more difficult to instruct or manage or whatever. And we go our own ways, and that is what has made America so great in so many ways. So, the things that you may see at a school in which we depend on all the local superintendents, on all the principals, on all the local health departments, the things that we set up as the guidelines, the things that you see where people are not abiding by and not wearing their mask or not socially distancing or whatever that you see are just a snapshot of what America really is all the time. And whether it be, you know, that we're spoiled in some degree, or whether it be, you know, we just become lackadaisical, or whatever it may be, you know, we are trying, Kenny, we are trying. We are telling these principals and the superintendents and everybody, and if we have a situation to where they can't be anything but 3 foot or whatever apart and everything, we've given them all the flexibility in the world. We've given the parents all the flexibility, saying to the parents, if you don't want your kids to go to school, we'll do it online. You know, we put up all the points of light to, you know, to be able to do it online. We are doing every single thing that we know that is capable of us to be able to do. Now, in that, you're going to have this, Kenny. You just are, you know, and we're going to have to, we're either going to have to buckle down and continue to try to do better in every way, or, you know, an alternative would be just to do this. And just imagine this. If we had not come up with the percent positivity compared to just infection, just the Harvard map, just think about this, West Virginia. Just think. Just in the Harvard map, if we would have said, well, I'll tell you one thing, we're just going to stay right to that map. Our deal is better. I don't care what the people at Harvard say. Our deal is more right than their deal. Now, the bottom line is just this. If we had just done the Harvard map, we would have a third to a half of our schools and half of our state shut down right now. Is that the right thing to do? I mean, really and truly in a state that has the best numbers of any state around, would that be the right thing to do? Would that be what West Virginians would like? I can't buy that. I can't buy that at all. And not only that, from a standpoint of just this, if we did that, how many people would we lose? I mean, you think about all the kids that are special ed kids or whatever it may be, and need to school so badly. I mean, where would we go? What would we do? And so I just tell you that no matter who it may be, the local health officials or the county superintendents or the principals or whomever, I can tell you that we got a lot of people doing a lot of really good work, but a lot of the problems and a lot of stuff that causes an outbreak in a nursing home, because we tell people not to go to Myrtle Beach and still they do, and still they walk right back into the nursing home and they're coughing or whatever, and then all of a sudden we have 15 people die there. Like it or not like it, but America, that's why we have 210,000 plus deaths in America. But it is also why we are the most powerful nation on the earth. It is also why our freedoms have made us the engine that runs the entire earth. Now, sometimes our freedoms can cause us difficulties, and we got to live with it, but that's just it. And Kenny, if we had that discussion, I know we'd agree with one another, but anyway, thank you a bunch.
All right, thank you, Kenny. Next to Mark Curtis with Nexstar Media.
This probably seems like an obvious question, but I've got to ask it, and I'd like the governor and Dr. Amjad to respond. You mentioned the success of Kanawha County, but tonight marks the first night Kanawha County will have high school football. I believe we're the final county in the state to host any games, and we have 4 games tonight. What's your advice to people going, fans, players, coaches, everybody? This is going to be a big deal tonight.
Well, I hope, Mark, they'll protect themselves and they'll socially distance through the stadium. And I hope that what they'll do is sit there and be really proud of those kids. And I hope they'll all have a great big smile on their face and enjoy the right that we have to be able and the opportunity that we have to be able to go back to something that's halfway normal, and I couldn't be happier for them. I really couldn't. I know that there's always some level of risk, especially till we get to this vaccine, but I think tonight they should really celebrate, and I'm really happy, and we've, by the grace of God above, we came up with a new metric and everything, or Kanawha County and Mon County or whatever may have been doomed forever, so I hope they have a great time, and I hope everything goes really well. And we're going to keep up our testing in Kanawha County, and we're going to keep it up in any of our counties. And you see, Mark, at the bottom line of the whole thing is just one thing, and that's just this: if they'll just come and get tested, we'll find the people that are spreaders, and we'll stop this thing. To the very best of all of our abilities, it's the only way in the world we can find them. You're not going to find any eggs on the egg hunt if there's no eggs out there. We have got to be able to have the test. So please, if the people that are going to games, if they'll do one thing that is the most important thing for me, is this: enjoy the game. Love the kids. Love the kids. And then, if they would, please look and go get tested. Every last one of them, go get tested. Because you may very well be the one. You may be the one that we save your life, that you don't get really sick. And you may be the one that is going to infect others that will die. And so if we can find you, we'll help you, and we'll stop this thing.
All right, thank you, Mark. Next, we'll go to Kimberly Keggy with WSAZ.
Good afternoon, Governor and panel. This is a question for Governor Justice in particularly, and this is something that you've mentioned several times over the last couple weeks, but there have been reports to our newsroom that community leaders are flooding testing sites to increase the number of negative tests in a county in order to withdraw those numbers down and help get kids back in person for learning following the school's county alert system. So what is the balance in helping those get tested who are asymptomatic and the balance of those who are flooding those testing sites? Thank you.
I think 2 or 3 things. First of all, by those flooding the testing sites, you're getting a better cross-section of the entire county than if we were just testing the sick. I mean, that makes complete sense, does it not? The other thing that it does is it does tell us that these people want to go back to school. There's such a need to go back to school. Every state in this country, with the exception maybe of not states, but maybe D.C. and Puerto Rico, other than that, every state in this country is back in school in some way or another. Now, don't hold me to every specific, but we want in this nation to be back in school. There's nothing wrong with people flooding a testing site because they want to go back to school. But the beauty of the whole thing, the beauty of everything is the more they flood, the more we'll find spreaders. I love it. I love it to death that the more they flood, absolutely, it could not possibly be better. You know, we found 85 spreaders last week in Kanawha County. What's it worth? Tell me, what's it worth? I have said this so much. What is a life worth? Do you not think that one of those 85 would have infected somebody that would have died? 85 spreaders we found that we'd have never found in just Kanawha County last week. What's it worth? What's it worth? I mean, for crying out loud, when it really boils right down to it, if they flood the testing sites, more power to us. We learn more. They want to go back to school. That's great stuff with me. Now, do we protect the school? Of course we do. Do we absolutely do any and everything we can to ensure that our teachers, our service personnel, and everybody are super safe? Of course we do. I mean, do you really honestly believe that I, in any way, would want our kids, our teachers, or our service personnel in a situation that could absolutely, knowingly cause them more harm? Of course I wouldn't. I mean, really and truly, at the end of the day, what we're trying to do is stop this thing, shut this thing down right now. And, you know, we're talking about all the different, everything, all the protocol that you can do, you know, from the standpoint of being able, or all the PPE and all the different things that we can do, from testing with Dr. Amjad to anything in the world that we can do to make things better and safer, and that's what we're going to continue to do.
All right, thank you, Kim. Governor, back to you.
Okay, I got kind of wound up right there and everything, but I love the fact that you know, let me say this, you know, our teachers are doing great work, our service personnel, all the people that are in our Department of Ed and everything, they deserve to be commended in so many ways. You know, all of the health officials on the call and the health departments and everybody that's done incredible work, and I can never thank them enough. And I always want to say that we, and it's not much I to it and everything. And you know, if I give you an opinion and I say I'm meaning we, because that's how this whole boat has sailed. And 134 briefings, it's hard for me to imagine. Gracious sakes, it's while they've been tough, time does go on. It's been an honor. It's been an honor to to navigate through this with you. And so, so with that being said, I'll leave you by just saying this. I wish those that are going to be at a football game on Friday night in Kanawha County, I wish them the very best, and I'm happy for them. I just think back about the fact that just in a matter of a very, very short number of days, even though that short number of days may be 134 more, and if that is 134 more, there'll be lots and lots and lots of life beyond the 134 more. And I hope and pray that it's a fraction of the 134 more when we have a vaccine or we have identified the spreaders and we have numbers that are absolutely spectacular beyond belief. So keep doing the great work. All the people in Upshur County, come out and be tested today. Please, please, please flood us. Flood us. I can't say it any more blunt, but somebody identify to me, just somebody identified to me, what is one life saved worth? You can't do it. You just plain can't do it. And so if we can just stay on top of it and everything, and we can continue to test and everything, like I said, we found 85 spreaders in Kanawha County in a week. We'll find some in Upshur County, and we'll stop this thing. So, just try if you can to get out and get tested. And if by chance you would test positive and everything, we'll repeat the test to just make double, triple sure. And there won't be any just false positives, around and everything. We'll try to repeat as much as we possibly can, to be able to make sure. But anyway, thank you so much.